Hey guys, so the appeals court in Michigan has made a fairly rapid decision in the case of Ethan Crumbley's parents, Jennifer and James, being charged with involuntary manslaughter. The short version is, based on these facts, not surprisingly, the court found the parents could stand trial. Let's look at what the issue was, how the decision was made, why it was an issue at all at this point, how it looks for them now that this ruling has come down, and what this ruling means for other cases. First, correcting what I said earlier in the weekly docket. I stated the Michigan Supreme Court had intervened at this early stage, which is unusual, and heard the case. Actually, the Michigan Supreme Court had intervened at this early stage, which is unusual, but ordered the Court of Appeals one step lower to actually do the hearing of the case. So that's corrected. Let's move on. In a manslaughter case as charged here in Michigan, the state needs to allege and ultimately prove facts to support these elements. This is what gets you thrown in prison. A death caused by the defendant without legal justification or excuse while the defendant was acting in a grossly negligent manner or committing an unlawful act that's inherently dangerous. So most of these are not issues in this case. I mean, we know people died. We know there's no justification for it. So the issue here is cause, primarily. The parents didn't shoot the victim. Their son did, intentionally. So common sense says, well, what did they do? Okay, but this is a legal case, and criminal statutes require proof of defined elements. So this requires a little bit of thinking from a legal sense. Put your law nerd legal cap on. The primary basis for the appeal really is cause, okay? And that, in the first instance, means factual cause. Okay, I can look at the facts and see the defendants did this. Ultimately, that led to the deaths occurring. I see the chain there. I see how what they did resulted in these people being killed. The second is the legal concept of proximate cause. And that means, basically speaking, the way the death occurred was, quote unquote, reasonably foreseeable to the defendants when they acted negligently. And we're going to get into that a little bit because that's a curious concept, worse than it seems just saying it. As the Court of Appeals said here, we can, quote, quickly dispatch with any argument that factual causation did not exist, end quote. The court said reasonably that a reasonable jury could conclude that but for what the defendants did, James and Jennifer, when they bought their mentally disturbed son a handgun, they failed to secure that handgun, failure to remove their son from school when he made overt threats to hurt other people. If they hadn't done those things and failed to do those things, then the 4 murders and several injuries their son inflicted that fateful day, they wouldn't have occurred. So that's factual causation done. You can send that on to the jury. A jury could look at that and go, yeah, you know, if you hadn't bought this gun and ignored all these things and then failed to secure it, and you just left it out in the open for this minor who was mentally disturbed, that led to these people getting shot. A jury could look at that and think that. And so that was contested on appeal, but just barely. The court wasn't having any of that. We looked at that pretty detailed in weekly docket. So the primary issue really was proximate cause. That is basically a limit to how far the law will allow causation to be taken before the law says, hey, the chain between negligence and injury is broken. And so that's when the court says the death is so remote from defendant's conduct that it would be unjust to permit a conviction. The way this is normally stated is that the death must be the direct and natural result of defendant's actions. Because as the defense attorney pointed out, yeah, you can find factual causation. I mean, if they hadn't gotten the mother pregnant and had the son, ultimately wouldn't have shot anybody. So, I mean, you can dig for factual causation and pretty easily find a link. So the law puts this limit on it. Now, more particularly, if something occurs between the negligence of the defendant and the death, and that thing really causes the death, that's called an intervening cause. And whether it's a superseding cause, in other words, it gets the defendants off, that gets couched into whether the defendant could have reasonably foreseen that this intervening cause would supersede. All right, we went full nerd there, lots of vague words and things. Let's get some real examples. Last time I talked about proximate cause with the old Chestnut case of the lady injured by the exploding kerosene lamp in a hotel she was staying at due to a train company being late, and she had to spend the night at the wrong place. Well, the court said, look, a train company may have been negligent in how they operated the train, but they couldn't have reasonably foreseen that a lamp would blow up in a hotel due to the hotel owner's negligence, and so they let the train company off. So they said, look, the intervening cause here, the hotel having a bad lamp there, that's just too remote. Train company can't, think of everything when they're doing stuff. So they let the train company off. it's kind of a wait, what standard for proximate cause? Like, what happened? And you couldn't have reasonably foreseen it, is the idea. So in this case, the court applied this in the criminal context, citing an 1878 Michigan case where the defendant punched a man who fell on the ground. And while on the ground, a horse either jumped on the guy or kicked him while he was down. That's very horse-like, and that killed him. Now, you could say the guy wouldn't have been on the ground next to a horse if he hadn't been punched. And that's true. That's factual causation. So that's there. But the court said they would only hold people responsible for the natural and probable consequences, not everything that's possible in every possible circumstance. So here the intervening cause of the horse became the superseding cause. The horse actually caused the death, not the punch. And the defendant, the court said, would not have reasonably foreseen a horse killing the man after he punched him once and he fell on the ground. Now, personally, I disagree because I think a horse will kill you anytime it gets the chance. And it's more likely to do that when it doesn't know you well. That's just me based on my own experience with horses. But I think you get the point here. The court's saying this weird thing happened. Wait, what? A horse kicked him? And so they didn't hold the guy responsible for that. Now, let's make up an example, I think, that shows this a little better than from 1878 and Yellowstone and all that stuff. So I punch you and you fall down and hit a rock on the ground. I'm probably going to be held to have reasonably foreseen that that might happen. Rocks are on the ground lots of times. There's not many rocks floating around. So if I knock somebody on the ground, then they hit a rock and get hurt, I should have known that would happen. But let's say I punch you and you fall down on a nice, soft, sandy spot, and a meteorite is hurtling through space, comes through the atmosphere, and happens to hit that spot when you happen to fall, and that kills you. Well, that's probably my lucky day legally, even if it's not yours, because I could reasonably foresee a rock on the ground, but can't we agree that we probably can't reasonably foresee a meteorite hurtling through space and landing on that exact spot at that exact time? That's even crazier than the horse. So there's your idea of proximate cause in a broad idea there. Now, all of that lawyering done, let's get to how this matters for the case. It's the general rule, meteorites and horses aside, that when a third party enters the scene and causes the death, either intentionally or with gross negligence, the law will say, hey, that person is intervening and they become superseding. In other words, the law says we're not going to say that you should reasonably foresee someone else will step in here and intentionally kill somebody just because you were negligent, taking advantage of your negligence. You don't have to go around reasonably foreseeing everybody's Jeffrey Dahmer or something like that, or Ted Bundy. So the court said, and I quote, if the intervening act by the victim or third party, though, was not reasonably foreseeable, in other words, this gross negligence or intentional Ted Bundy-like misconduct, then generally the causal link is severed and the defendant's conduct is not regarded as the proximate cause of the victim's injury or death. So, yeah. So if I run into you on the road while driving recklessly and knock you into another lane and an 18-wheeler is coming the other way and hits you and kills you, I'm probably going to jail. If I run into you and it causes your car to stop, and while you're waiting on the side of the road, Ted Bundy comes by and kills you, maybe I'll get off because that's his intentional conduct, taking advantage of the situation, nothing I could have reasonably foreseen, the law says. So that's the idea. And the defendants leaned heavily on this legal principle in this case because the son's acts were intentional. But the court said, and this is why lawyers say it depends all the time, as with many things in life, this rule is not as black and white as defendants suggest. And the court said, look, hey, yeah, parents are not generally responsible for what the kids do. But that principle is just shorthand for, going back to the beginning of the video, this causation and proximate cause is reasonable foreseeability. It's not magic language that automatically protects the defendants. People like to think there's magic language. We talked about that a lot in the Brooks case, and certainly the defendants were trying to use it here, but usually language in the law is trying to get at a concept, and that's the case here. So the court stressed, hey, look, this case is super unique, lots of unique factors. And he took several steps to say, look, when we decide this baby, we're not changing the law and we're not increasing the amount of people who can be charged with crimes. And, you know, in the oral argument, they were concerned about that. And the defendant basically suggested, if you hold these people over for trial, let them be convicted, every parent everywhere is responsible for everything their kid does. And the court said, well, we're not going to do that. They said that even in the oral argument. I think they tipped their hand on that. So the court said first, The principle that other persons' intentional or grossly negligent acts are superseding causes, in other words, they relieve you of being responsible, that's not changed by this decision. We're not changing that law at all. Still the way it is going forward. But under the unique facts here, and the fact that this is before trial when facts aren't really sorted yet, and so you have to, give some deference to the trial court, that this is a special case. Then they said that based, quote unquote, solely on record evidence, this case is uniquely troubling. There's a lot of unique in here, a lot more than you normally see in appellate decisions. And in case anyone missed the point of how they were trying to limit this decision to this case, they said, this point is important. That's a tip-off that it's important. As although the judiciary typically recognize that a decision's precedent is limited by the facts at issue, it is particularly true when the court expresses that limitation, end quote. They gave their decision, but they let everybody know, look, this is just for this case and just under these facts. And this is no new legal principle or we're not changing the law here. We're just applying it. But what swayed the Court of Appeals to deviate from the general principle that somebody else intentionally killing somebody is not something you should foresee when you're negligent. And they cited a lot of facts, and they're really bad. And we'll hit them generally and then a little more specifically. But the court cited here, the defendants were aware that Ethan had hallucinated and had extreme paranoia, saying that they knew about his fragile mental state and that he was in a bad place. They knew he was distressed due to a loss of a grandparent, loss of his dog, and his best friend leaving. He even told them, look, I'm in a bad mental state. I'm hearing things, seeing things. And he asked his parents for medical assistance, which they kind of laughed off, told him to suck it up, he said. And knowing all this, they bought him a gun. Of course, they didn't secure this gun or keep any limits on his access to it in the record. The day before a shooting, he was researching bullets in school. The day of shooting, he watched a video at school involving a shooting, and he drew pictures of a bullet, a gun similar to the SIG his parents bought him, a bleeding person, wrote blood everywhere, the thoughts won't stop, help me, my life is useless, and the world is dead. Then the court said, look, they left him in school after that. The school said, look, you need to take him home now and go get him medical help right away. Well, they didn't do that. They didn't tell the school anything about his mental struggles or say, well, oh, just so you know, we bought him a gun, even though he's a minor. He's got a handgun just sitting around. They didn't ask or check their son about the gun. They didn't check at home about the gun, even though he was drawing the gun and somebody being shot by it. So the court said, listen, this is all so intertwined. This is not even really an intervening cause, okay? This stuff is all connected. Like you were actively involved in not treating the mental symptoms. You provided the actual weapon, and you refused to remove him when you were asked to do so. And that's really enough to justify the legal decision, of course, but the court did lay out a fuller fact narrative, and I think it's worth going over. It's hard to believe, but lawyers and judges are people too, and the treatment of this child by the parents seems callous and reckless. It's just awful. So the record of facts available on appeal, they don't show when the parents first knew that Ethan was having some serious mental troubles, but they do give some examples well before the decision to buy him a gun and how they treated him. Let's look at this text exchange at 7:50 at night. Can you get home now? Ethan texts to his mom. There's someone in the house, I think. Someone walked into the bathroom, flushed the toilet, and left the light on. I thought it was you, but when I came out, there was nobody home. There's no one in the house. Dude, my door just slammed. Maybe it's just my paranoia, but when are you going to get home? She didn't respond that night. She was out horse riding, which seems to be the theme of their interactions with each other. A week later, he sent his mother text messages reflecting his belief that a demon was in the house, throwing things around, and he had a picture of it. Okay, the house is haunted, he says. Weird crap just happens, and now I'm scared. I got some videos and a picture of the demon. It is throwing bowls. I'm not joking. It messed up the kitchen. And I'm just going to be an outsider for a while. And she didn't respond back. When he hoped she would, he wrote, can you at least text back? She did not text back anytime that day because she was out riding a horse again and didn't bother to respond to these messages from her son. An interaction between the father and the mother. A couple of days later, she messages the husband saying, how is Ethan doing? And he says, he woke up looking like he had way too much to drink last night, complaining about a headache. And she says she's not surprised by that, saying he was really worked up and out of control. I can see why. And she says all he needs to do is go eat, go to work, and work hard and not complain, and he can get his stuff back. Now remember, this is the guy who was talking about seeing demons and things like that. Then the husband tells her something that Ethan said that morning, saying, let me ask you a question. Why am I in your guy's room? LOL, the husband says. And then she goes, OMG. And he says, I totally thought you were giving him a Xanax last night. And then she talks about giving him some melatonin and things like that. So that's the care and concern over this kid being disoriented, not knowing what's going on. Had been telling them he was seeing things, hearing things. A couple of days later, still in March 2021, he sends his mother several text messages saying, I cleaned until the clothes started flying off the shelf. He wasn't speaking figuratively. This stuff only happens when I'm home alone. I picked up the clothes back up, though. She was at the barn with the horse, and she didn't bother to respond. Now, he was also texting with his best friend, and in April of that year, he said, I'm going to ask my parents to go to the doctors tomorrow or Tuesday again, but this time I'm going to tell them about the voices. I only told him before about the people I saw. Ethan had researched his symptoms and thought he was having a mental breakdown. Later, Ethan tells his friend he did ask his parents for medical help, but that the father refused, gave him some pills, and said, suck it up. The mother, according to Ethan, laughed at the request because she didn't believe he had mental health issues, but instead was using drugs. He told his friend, this makes me feel like crap. He said, I even thought about calling 911 so at least someone would take me to the hospital and I could get help. But he didn't do it, he said, because he was afraid his parents would be angry with him. In October of that year, as they're closing in on the time that the shooting would occur, Ethan's still talking to his friend about his belief he has a mental breakdown. In the defendant's text conversations, the mother and the father show no indication that they considered finding any help for Ethan. Now, it was near the end of October when Ethan's conversations with his friend stopped. His friend had to leave and go, I think, get some help of his own. His grandparent died, one of them, and his dog died. So the mother told her friend who had the horse place that she thought he was having a hard time for these reasons and all these things in quick succession. Now, according to this woman who owned the horse place, the mother didn't speak about her son very often, but when she did, she described him as weird and said he had no friends. Now, the court notes that Ethan also kept a journal, and that referenced his friend. It had a drawing of a decapitated bird, depicted a demon, and discussed various other issues in his life. The court noted that every one of the 21 pages of written material had reference to plans to commit a school shooting. He said, I will cause the biggest school shooting in Michigan's history. I will kill everyone I effing see. He also wanted to shoot a pretty girl with a future first, so she can suffer like me. And he drew a picture of that occurring. He also mentioned his parents, saying, I have fully mentally lost it after years of fighting with my dark side. My parents won't listen to me about help or a therapist. I have zero help for my mental problems, and it's causing me to shoot up the effing school. Now, there's no information that the parents read this journal, but that was his state of mind, at least as he was expressing in it. But the evidence is there, of course, that he was telling his parents he's seeing demons, hearing, thinking people are around that aren't there, asking to go to a doctor. I mean, he's a kid, so that's not usual unless the kid has a serious problem and wants help. But while not getting help for the demon-seeing son and the clothes flying and bowls flying and someone's there is not there, they don't go get any help for him. But what they do is on November 26th, they go to a gun shop and purchase a 9mm SIG handgun. Of course, the father has to do this because the son can't legally do it. And the gun comes with a lock, of course, and an ATF youth handgun notice that tells you about the dangers of kids getting hold of guns, which should be obvious to people, but it seems to not be. Later that day, Ethan posts pictures saying, look at my new gun. I got my new baby today, my new beauty. The mother sends a picture after they go to the range talking about it's a Christmas present, early Christmas present for the son. So they treated it as if it's his gun, which I'm not certainly anti-gun for teaching kids, teens how to shoot, things like that. But every situation is unique. And maybe when they're seeing demons and things like that, it's not potentially not the time to spend the money on a gun instead of help for the kid, I think. Anyway, the mother purchased a range time for herself and the son and bought, it says 2 boxes, so 100 rounds of 9mm ammunition. And then they shot at some and took the extra ammo home. I guess that's what he ended up using. So this gun was bought on November 26th, but on November 29th, Jennifer does finally perform an internet search on treatment options for clinical depression. Hopefully that was relating to her son, maybe. But meanwhile, he's back in school. And then a teacher sees him looking up bullets on his cell phone. He's got an explanation for that. I was trying to figure out what kind of bullet it was. I shoot guns with my parents, things like that. He was calm and cooperative with the school, so that didn't really go anywhere. And the mother brushed it off as well, saying, seriously, you're looking up bullets in school and you have to learn how to not get caught. So finally she's talking back to him. I guess it had a little break from the horse. So then it comes down to the day less than a week after they bought this mentally disturbed child a gun and left it where he could get to it. He goes to school to carry out this fantasy he's had of shooting in it. And on the morning of November 30th, Jennifer goes to her real estate job and James goes to the barn to check on the horse. And the kid goes to school, and in his backpack is the SIG handgun and his journal about shooting everybody. Now in the early class, he's caught watching a video of somebody shooting people. And that gets forwarded around school to the authorities. They catch up with him at the next class, which is math class. And he's drawn a picture of a handgun that's pretty much his SIG and a body next to it with blood out of it and obviously shot, saying, "The thoughts won't stop helping me. My life is useless. The world is dead." Now, you may feel that way when you're confronted with having to do math problems, but this isn't abstract. This is real life. And this kid was obviously highly disturbed to write this stuff down where someone's going to see it. I mean, can there be more of a last ditch cry for help sort of a thing? Well, the school figured that out, of course, and they took him to the office, called the parents. Meanwhile, the kid takes the drawing back and tries to cross all that out, make it look like it's great. Everybody knew what it already said because they'd had a picture of it. So he tried to excuse it, saying, look, it's just a video game. I want to be a video game designer when I grow up. But that, wasn't really fooling the school. And the school left a voicemail for Jennifer, and she called the father. Neither one of them answered, but the mother did call back, and they said, can you come to school? We've got to discuss Ethan's situation. And this is before the shooting. He's got the gun at the school. He's drawn up this paper of somebody dead with that gun next to them and saying, the thoughts won't stop. Help me. So she texts the father saying, call now, emergency. And the father, she sends him a picture of what the kid wrote on the math photographs. And he says, my God, WTF. So the parents head over to the school. And when they're in there, the person who met them, the administrator, said they didn't touch, greet, or hug Ethan. And the school person thought that was bizarre. Maybe. I mean, it kind of sounds like it. And the school told them, look, here's the video he was watching, what it was about. And look at this math worksheet. We're really worried about his mental health. And here's some resources. And we want you to immediately take Ethan to a doctor or therapist today. Now, Jennifer says, oh, well, nope, I can't do that because I have to work and my husband has to work. And apparently James did not disagree with that. So she's like, no, we're not taking him out of school for this. And the school person said they were surprised at that decision, but you need to get Ethan help within 48 hours. Because there wasn't something he'd done that required them to leave school, the school let him stay there. And the school even thought, well, maybe it's better he's not alone if his parents are going to take off to work because he's having suicidal ideation. The school said during a 15-minute meeting, Jennifer did not speak to Ethan at all, but the father did and said, look, you got people you can talk to, including us, and you should write more in your journal. The school said then that the mother abruptly, it's a little bit of a judgment call, but I get it, asked, is this meeting done? The school said on the way out, the parents, neither one of them hugged or said goodbye to Ethan. And the school person said, they told Ethan, I just want you to know I care about you, because the person believed Ethan was not getting parental support. The school person thought, they're not going to get this kid any help. I'll check back in with him tomorrow morning and see how he's doing. Now, nobody at the school or the defendants asked to look in his backpack. And that had, of course, the journal and the gun in it. The parents didn't mention the fact that they had just bought this kid a gun less than a week before that looked like the one in the picture. They didn't mention that. They didn't mention that it was unsecured at home and he had full access to it. None of that was mentioned. So they leave out of the school, and this is in a series of facts I think just makes them look worse, whether it was reasonably foreseeable or not, but it was. So they take off. 2 minutes later, Jennifer contacts the horsewoman to discuss the horse riding lesson scheduled for that evening. And then she tells about what happened at the school and forwarded the pictures of the math worksheet. But I'm still going to come, she says. And the horsewoman says that she was alarmed by the violent drawings and aware that there were guns in the house. And she said, well, maybe he could do horse therapy. And the mother responded, yeah, well, he'll be coming out with me tonight. James is working. Ethan can't be left alone. So the horsewoman nicely says, does he want to ride a horse? The mother writes, maybe brush a small horse so he's not intimidated, LOL. Now, the father takes off out of the school parking lot and logs into DoorDash and accepts his first delivery job at 11 a.m., 4 minutes after driving out of the school parking lot. So, some real serious obligations that these parents have. And by the way, I'll mention that, so I don't think it's in this court record, but that the head of the place where Jennifer worked said, look, she had PTO available. Plus, if she needed to work from home for the rest of the day with her kid, I mean, we let people do that. We're responsive to family issues, family friendly. So it was some nonsense. Anyway, Jennifer goes back to work and tells her coworkers about the school meeting and says, hi, he's lonely. Look at what's going on with him and check out this math worksheet. She told some of them she felt as a failure as a parent, and this is disturbing and all of that. But one coworker said, yeah, I think she was just being sarcastic about it. Yeah, I don't know. I wasn't there. So at 12:21, though, she finally sends Ethan a text message saying, are you okay? And he said, yes, just finished lunch. And he says, you can talk to us and we won't judge. He says at 12:42, I know, thank you. I'm sorry for that. I love you. She doesn't answer that. And then 10 minutes after that, less than 10 minutes after that, he goes into the bathroom with his backpack, comes out with the gun, and commits the murders, killing 4 people and injuring 6 students, teacher. A few minutes later, that's all over. So the school, though, sends out an alert to parents, hey, there's an active shooter within the school. So she receives the information, the mother, and starts screaming at work. Upon receiving the alert, the father drives home immediately and looks around for the SIG and ammunition. He's got that in his head already. And just after 1:18, the mother finally responds to Ethan's last text. 1:18 after this, this school shooting issue, and she sends back to him, I love you too. You okay? And then 4 minutes later, she texts him, don't do it. Okay, nice. I wonder what she's thinking about there. Reasonably foreseeable? Yeah. So then the husband tells the mother, the gun's missing and the ammunition's missing. Because she sends a text message to a coworker saying the gun is gone and so are the bullets. So the coworker says back, I'm praying everything is okay. And the mother says, oh my God, Andy, he's going to kill himself. He must be the shooter. I need a lawyer at substation with police. Ethan did it. I need my job. She texts this later. She actually texts this later while her kid is a school shooter. She says, I need my job. Please don't judge me for what my son did. At any rate, the husband is not sitting on his hands either. At 1:34, he had called 911 and told the operator, my son goes to this high school. There's a gun and ammunition missing from the home. And I think he took the gun and he's a school shooter, the father says. The horsewoman said that when she heard about it, she immediately thought he did it. And given the drawing on his math worksheet and gun ownership, that made sense. So on the day of the shooting, of course, the police go over to the parents' house and they do a search warrant. And in the parents' bedroom, they found the gun case for the Sig Sauer open on the bed next to an empty box of 9mm ammo, a locked safe in a dresser drawer of the defendant's bedroom, and that had a 3-digit combination lock, which was 000, and that had 2 other guns in it. All the gun locks in the house were still in their original packaging. There were no broken locks or something anybody tamper with to get a hold of the gun. In the kids' room, there were a lot of paper targets and shell casings and folding knives. To me, none of that's abnormal for a kid, particularly a boy. A notebook containing detailed drawings of guns. And feces of a small animal were on top of the nightstand. I'm not sure why they wrote that or what difference that makes. But that's what they found at the house. So those are the facts at the appellate level. As alleged, there were certainly more that the prosecutor had. This is just a sad case. Even the defense attorneys on appeal acknowledged to the Court of Appeals, these parents made terrible choices, but they just shouldn't be held legally responsible. It's not always a situation that the person who has the mental health issues asks directly for help. And then that help is laughed away. And then for this person who is significantly struggling, he's provided with a gun. I can say these people would not want me on a jury if these are the actual facts. I would vote guilty based on this. Of course, there could be other facts or disputes, but in my opinion, the court was totally correct to send this case forward. Let the jury look at it. This is way past the minimum level to face trial. This case isn't about guns in particular, but it hits important points. And I'm pro gun ownership, and I think you should be surprised by that watching this channel, but I'm also pro responsibility. And when you put a gun into the hands of a troubled minor and you don't do a single thing to ensure safe use, and you ignore the struggles of the child while providing that child a deadly weapon, well, it ain't the biggest injustice in the world if you're held responsible for that. Again, the court decision, in my opinion, was exactly right. Now, this case I looked at a little more closely because it was brought up to me to compare with Brooks' mother, Daryl Brooks' mother. I've said why I think she hasn't been charged, the likely reasons for that, and they kind of do hit on this issue of reasonable foreseeability. And while it's not a good idea to compare cases across states involving different statutes and different court standards and different facts, I do agree the general issue is the same, reasonable foreseeability. What does it take for you to be responsible to some degree criminally for the criminal acts of another? I think the Brooks case is at the limit of that due to this issue of proximate cause. And this one is too, and thus the early involvement of the appeals court and the limiting of this decision to the facts of the case that the court was very clear about. If you see a parallel here, nevertheless, to the idea of culpability for someone repeatedly aiding Brooks in breaking the law and providing him the weapon he used that he was not legally allowed to operate, I get it. I get it. Again, I think we're operating at the margins of the law, which may be a little bit surprising to people, but I see what you're saying because the equity is terrible, just like it is here. But even within Michigan, and Michigan cases only, matter directly to Michigan, they said, look, this is a special case on these special facts. So it's not some new change in the law, but I think it is fair. I think probably most people do. So back on this Crumbley case, here we are with a kid who wanted to commit the biggest school shooting that his state had ever seen, as if that were an accomplishment. The moral anchor to think such an idea was heinous, it was just lost for him. He wanted others to suffer because he felt suffering, he said. He wanted to be known for something because he didn't think he was going to be known for anything. And none of those excuses at all. But that's the mental state he was in, and he asked for help. Instead, he got a gun, some drugs, and mockery from his parents. And those acts resulted in a disaster, but one that was foreseeable enough that when first hearing of it, the parents' thoughts immediately turned to the gun they had bought and their own son. So yeah, it was reasonably foreseeable that the things they did could lead to this kind of result, and it ought to be plenty reasonably foreseeable to them now that they will be held accountable. Thanks, bye.